How to get a legal opinion for your token. How can one day change your entire life? We have already learned and are ready to share it with you. In the meantime, we invite token issuers and young startups to learn about a crucial document, the legal opinion. How to obtain it, what it entails, and how much it costs. We understand all of these matters. Satoshi Nakamoto sought to create an anonymous and decentralized method of payment that would not only address banking issues but also be entirely independent of the state. However, it is nearly impossible to implement such an idea and establish a currency that remains unregulated by the government. That is why token issuers need to understand how to avoid legal problems during the ICO or listing. The solution lies in obtaining a legal opinion. What is the token legal opinion? A token legal opinion is a formal document prepared by legal professionals that provides an assessment and analysis of the legal status and regulatory compliance of a token or cryptocurrency. It offers an informed legal perspective on various aspects of the token, including its classification, potential legal risk, compliance with applicable laws and regulations, and the rights and obligations associated with it. Requests for a legal opinion on a token are usually received from token issuers, projects, investors, or exchanges, in order to obtain a comprehensive understanding of the legal implications of a token offering or related activities. These opinions are important for ensuring compliance with relevant laws and regulations, minimizing legal risk, and ensuring transparency for stakeholders. Why do crypto projects need legal opinion? Token legal opinion allows you to confirm or refute the classification of a token as a security, thereby solving a number of legal and economic issues related to the token. Cryptocurrency exchanges may require you to provide legal opinion in order not to run into tax issues or securities regulations. As a rule, legal opinion addresses the following aspects. Will the token meet the definition of a security under the law? To do this, they conduct the Howey test, the family resemblance test, and the risk capital test. The next aspect is whether the token will meet the definition of security according to the legislation of the jurisdiction in which the ICO is being structured. The third aspect, will the sale of the token fall under the legislation on collective investment schemes? Finally, does the special legislation on distributed ledger technologies apply to the sale of tokens in this jurisdiction? If an asset meets the definition of securities, it will be regulated by special authorities. In the US, this is the SEC, Securities and Exchange Commission. Real cases in the history of cryptocurrencies. In the short history of cryptocurrencies, some token issuers have already faced a difficult struggle for the right to be considered a cryptocurrency and not securities. Perhaps the most striking example is the history of Ripple and its XRP token. At the end of December 2020, the US Securities and Exchange Commission accused the California startup Ripple of illegally issuing securities in the form of XRP tokens. The regulator alleges that Ripple has violated federal securities laws and sold $1.3 billion worth of unregistered XRP token securities since 2013. SEC experts are confident that XRP fits the classification of security in accordance with the Howey test. Ripple vehemently disputes the SEC's accusations and claims that XRP is not a security and that the SEC has generally exceeded its authority in this matter. The trial is not over yet, and its outcome could greatly affect the cryptocurrency industry. In fact, the Howey test we talked about earlier has been used in finance for 77 years. And at first glance, it is quite simple. It includes only 4 aspects. First, the project is related to the investment of money. Second, investors invest in money with the expectation of making a profit. Third, investments are directed to a common enterprise. Fourth, the profit expected by the investor is related to the activities of other persons. Positive responses to these aspects increase the risk that the token will be recognized as a security. However, the Howey test is not the final decision. Do all tokens really need a legal opinion? The launch of tokens can be carried out in different ways, but the essence of any token offer is its subsequent placement on a crypto exchange and providing it with a liquidity. The legal opinion will confirm or deny that this token belongs to securities, and this will determine further ways of regulating the token on the exchange. But before making a verdict on the nature of the token, they analyze it and determine which category it will belong to. Token issuers need to know this in order to understand what the result of a legal opinion can be. There are several types of token use cases as legal notes notice. Protocol tokens for launching decentralized applications, smart contracts on a blockchain protocol. Access tokens for receiving access to the software functionality. Loyalty tokens for receiving discounts, such as reduced fees for services or digital goods. Community tokens for receiving access to communities, such as entrances to events or invitations to various community platforms. Payment tokens, stablecoins for making payments. Asset-backed tokens that provide rise to a real asset, such as plots of land, square meters of real estate, or grams of gold. Security tokens for receiving dividends and rights to participate in profit distribution. Governance tokens for participating in voting on the future development of the project. NFT non-fungible token provides rights to non-fungible objects, including works of art. Once there are defined use cases for tokens, legal commissions proceed to the legal classification of tokens. There are also several subtypes in terms of legality. Utility tokens. These include protocol tokens, access tokens, loyalty tokens, and community tokens. Security tokens include dividend tokens, asset-backed tokens, some governance tokens, and some stablecoins. Payment tokens and stablecoins refer to financial instruments, e-money. Finally, NFTs are determined as digital goods and assets. Legally, the distinction between utility tokens and security tokens is important. Utility tokens are not valuable. If the project becomes successful, investors are not entitled to a portion of the profits generated, as will be the case with some traditional securities. But when investors buy a security token, they are buying stocks, bonds, or derivatives. Their tokens actually serve as investment contracts and guarantee the ownership of off-chain assets. Thus, the release of security tokens in the US is regulated by the SEC, and utility tokens are not recognized as securities. Therefore, the issue of special taxation and circulation of tokens does not fall within the jurisdiction of the Commission. What to check when getting a legal opinion? To obtain legal opinion, token issuers should contact lawyers, preferably those who specialize in the regulation of cryptocurrencies. The lawyers should be familiar with the legislation of the state in which you will launch the tokens. A high-quality legal opinion for cryptocurrency exchange is distinguished by the strictness of the wording, the clarity of the circumstances provided, the validity in accordance with the law, as well as the presence of transparent and understandable conclusions. If your activity has violations but you receive a positive opinion, do not rush to rejoice. A good lawyer will never issue a legal opinion to token issuers who break the law. You should be warned about violations, and only after they are corrected, you should be provided with an opinion. Otherwise, you are faced with non-professionals, perhaps even scammers. Legal opinion is an expensive document. The service can cost $1,000 or more. Find out exactly how the check will be carried out and what is included in the cost. Services that are too cheap should alert you, while services that are too expensive may not be suitable for you. What is the structure of the legal opinion? The final report with legal opinion should have several mandatory elements. Information about the customer and the contractor, including the addresses and contact details of each of the parties. General summary of all documents that were examined for preparation of the legal opinion. In addition, the report should contain references to the laws in force that justify the contractor's decisions. Legal opinion of a lawyer on the legality of the token, potential risks, and other facts related to the legal regulation of the token. Date and signature of the drafter of the legal opinion. Most often the document is signed by the director of the company manually. When receiving the document, check the date of its compilation, because the legislation may change after the issuance of the legal opinion. To avoid litigation, always look at the date. If there is an error in it, demand that the conclusion be corrected, because such a small detail can turn into serious consequences for you. Legal opinion is not a guide to action and a substitute for legal support. Keep all supporting documents in one place and remember that even legal opinion is not 100% protection against possible legal problems. Your token is your responsibility. Now you know that one day can change your entire life and future work. However, this holds true only if you check the date of the legal opinion. We hope our advice on how to obtain a legal opinion, what to consider, and how much to pay for the service has been helpful. Don't forget to explore our channel for more videos for Web3 developers. Check them all out.